Now, Justice Alito disagreed with the majority opinion. Justices Thomas and Gorsuch joined the opinion in full, while Justice Kavanaugh joined in part. For more than 100 years, federal law has designated the Tuesday next after the first Monday in November as the day on which United States senators and members of the House of Representatives are elected. That's 2 U.S.C. Section 7. Setting the date as a day for the election of members of the House of Representatives. Section 1, United States senators shall be elected on that same date. Similarly, federal law has long provided that the electors of president and vice president shall be appointed on that date as well. That's 3 U.S.C. Section 1, subsection 2. And because the appointment of electors in each state is now decided by popular vote, voters express their preference for president on that same date. So far, I think all parties agree on these facts. However, by pointing out that electors of president and vice president shall be appointed on election day, Justice Alito does add a new twist. See, although the states decide which electors to appoint based on a popular vote in the state legislature is still required to appoint electors on that date, which cannot be done if they're still waiting for ballots to arrive. As the court explains, an election is the expression of the electorate's choice, but because the electorate is a collective body consisting of many individuals, the way in which it expresses its choice is less straightforward than would be the case if the electorate were a single individual. If the electorate were an individual, it could issue a document declaring that the specified men and women were selected to fill federal offices for which they are candidates and competed. But because the electorate is a collective body, it cannot express its selection in that way. Instead, its choices are embodied in the collection of ballots cast by the individuals who make up the electorate. Taken all together, this collection is the equivalent of a single document declaring the winner of each race. Now, if an election is the act of choosing, when is that choosing complete? How do we know what the collective choice of the electorate is until the ballots are not only cast, but counted? And how can they be counted if they're not yet received? This expression of the electorate's choice is conveyed to the responsible election officials when the collection of individual ballots is completed. At that point, the electorate authoritatively expresses its choice, and what the Election Day statute demands is that this authoritative choice be made on Election Day. If ballots received after Election Day are added to the set of ballots that dictate the election's outcome, the electorate's choice does not occur on Election Day, and the federal Election Day statutes are violated. According to Justice Alito, the election isn't complete until the votes are collected, and that is when they are officially cast, which is a problem for Mississippi law. In this case, we must apply this interpretation of the federal Election Day statute to a Mississippi law that requires states' election officials to accept ballots that arrive up to 5 days after Election Day. The acceptance of these late arriving ballots effectively postpones the date on which the elector's choice is made, and federal law precludes that postponement. Justice Alito believes Mississippi's law violates federal law because ballots can be accepted after Election Day. But there's a little more to this decision. Election Day is a specified date, not a span of multiple days. The Election Day statutes require that federal elections occur on that date. Under the challenged Mississippi law, however, the collection of ballots continues for 5 more days, and therefore the election is not held until the end of that period. Because federal law requires that the election occur on Election Day, it preempts Mississippi statute. Justice Alito is wrong in one point. Federal law does not preempt state law because they are different, but because of the Supremacy Clause of the Constitution, which reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." Is there a historical basis for Justice Alito's position that Election Day must include both casting and collecting ballots? 2 centuries of historical practice reinforce the proposition that holding an election on a particular day means that poll workers have to receive the ballots by that date. From this country's founding until the late 20th century, Election Day ballot collection was the near uniform practice, with only few late arriving exceptions. Before the Civil War, nearly all voting occurred in person at polling places, so Election Day was ipso facto the day on which the poll workers collected all the ballots. If, at the time of the ratification of the Constitution and the passing of federal laws on the subject, an election included not only the casting of ballots, but collecting of same, it would appear Justice Alito's position is the correct one. For this reason, I would affirm the decision below, which held that the provision of Mississippi law requiring acceptance of late ballots violates federal law. Because the court reverses that decision based on a flawed understanding of Election Day statutes, I respectfully dissent. Which of the two positions do you think is a flawed understanding of Election Day statutes?